I'm the clerk for Marion County. I want to welcome you today. Today is Confidentiality and Redaction of Court Records. We're going to begin today with our panel and give you a history and a background that most of you, I'm sure, know. But, Rule 2.420 became effective in October of 2010. Honorable Chip Shores and myself were on the original committee. The original Confidentiality Committee met, published a document. At that time, said that the clerks would be responsible for all 1,000, 2,000 plus redactions in the law. The second committee was established, and which we were on, and then we created and talked the committee into only recognizing the 20 or so that are now recognized as redacted issues. Many Florida Bar committees and SCTC have been instrumental in revising this rule lately since it's published in October. And another rule that's coming out that will greatly, and I believe greatly benefit clerks, is the minimization rule. This is going to require, you're going to hear it first today, the committee's going to address it, filers to not provide specific information in the documents they file. And a lot of the forms have been changed for the Florida Bar and will be changed. So you're going to hear that rule, and then they're going to go into the 2.420 rule. Our panel today is, as I mentioned, is Honorable Chip Shores from Manatee County. His presentation, the committee's going to, panel's going to present the minimization and the rule first. We're going to have a break, and then Mr. Shores and his staff will present their processes within Manatee County. Manatee County was first recognized as a beta site for specific processes that the Supreme Court recognized. So that's why they're here today. They're working closely with the Supreme Court on that. Others is Marynelle Hardee, Chief Staff Counsel with Alachua County. Merrily, Longacre, Assistant Court Director with Brevard County Court. Glynn with Marion County, Staff Attorney. Vanessa Steinerts from General Counsel from Broward County. And Jeff Taylor, Project Manager with Manatee County, who will help Mr. Shores later on. So welcome them if you would.
Good morning, everybody. I'm Glynn. I work for Mr. Elsperman, and I've been very involved in this confidentiality issue from the beginning. So I enjoy it, believe it or not. But today, what this panel is going to do is we're going to present the minimization rule first. Then we'll talk about Rule 2.420, the confidentiality rule, the current one, and then the proposed changes to it. And we'll also touch briefly on the e-service rule, the proposed e-service rule, and redaction. And we're going to ask that you hold your questions until the end of the presentation, just because I think it's likely if we start talking about our practices and how we redact in each county, we're not going to get through all this information. So we'd like you to hold your questions until the end of the entire session, which will be after Mr. Shore presents his system. And if you have a burning question that you can't wait, if you can write it down and hand it to somebody with FACC, because we want to make sure if it's something that you would like more clarification on, we'll spend more time on it. But if, in general, try to hold your questions till the end, please. We'll start with the minimization rule. This is basically to encourage filers to not put sensitive information in court filings. I think everybody knows that the Supreme Court recognizes that attorneys and pro se litigants have been putting a ton of sensitive information that is unnecessary and is not required by any rule or statute in court filings. I don't know, I guess it's just because it's always done that way, that's what they're used to doing. But as we get closer to providing court images of all court records to the public on the internet, it presents more of a problem. So this is their main, their first step in trying to encourage filers to not put that information in court filings. It's part of the overall effort to provide safer information to the public. Obviously, right now in Marion, we have the extranet, which allows only attorneys to see court images. And we're not allowed to provide court images to the public yet, with a few exceptions. But these are steps that the Supreme Court are taking to get to the point where when we do provide court images to the public on the internet, it should be safer for the individuals that have their sensitive information in court files. So I have a quote here at the bottom that 2.425 governs the filing of sensitive personal information, which is the linchpin of the minimization efforts. Both attorneys and pro se litigants must be vigilant to file only authorized documents that comply with this rule. The very good thing here for us to know is this rule applies to filers, not to clerks. It does not put any duty on clerks in any way. So it's very important today. We'll be talking a lot about the fact that clerks do have a duty under Rule 2.420. We do not have a specific duty under this rule. It applies to filers only. There are potential sanctions if the court finds that filers are just ignoring this rule and continue to include all kinds of sensitive information in their filings. And it allows an attorney to make a motion for those sanctions against another attorney or party, or the court can, find sanctions itself. So we'll see how that goes. I mean, right now, I still think this is such a new rule that the court is probably pretty far from ever finding for sanctions against anyone, because honestly, I think there's still confusion about this rule and the confidentiality rule, even among judges. So it's a process of education that needs to happen. The current rule does not apply to traffic cases or criminal cases, and that was kind of a temporary finding by the court. Since this rule went into effect, the court has asked that the Criminal Procedural Rules Committee, the Rules of Judicial Administration Committees, and the Traffic Court Rules Committee work together to create a tailored rule that would apply to traffic and criminal cases. They've asked those committees to come up with something that mirrors pretty closely the federal rule. It's Federal Rule 49.1, privacy protection for filings made with the court. So they realize that these types of cases, traffic and criminal, contain a ton of sensitive information. So right now, those committees have worked and come up with proposed rules that would make this minimization rule applicable to those types of cases. The most important thing, I think, here is that the minimization rule has to do with sensitive information. It is not the same as confidential information. But, as you'll see here, some information is sensitive and confidential. For example, Social Security numbers. That's confidential under the Rule 2.420. It's also considered sensitive information in the minimization rule. But, for example, driver's license numbers, telephone numbers, email addresses are considered sensitive information under the minimization rule. They're not confidential under the Rule 2.420. So that is creating a ton of confusion in the legal community and among filers, judges, attorneys, everyone. But that's a huge difference. And the most important thing for us to remember is that we don't have to redact sensitive information. In fact, we don't have authority to redact sensitive information. Okay, that's a huge difference.
And the minimization rule points out that unnecessary sensitive information should not be filed, but if it's required by rule or statute, it should be truncated in specific ways or masked in specific ways. And I'll go through here the ways that such sensitive information is supposed to be masked, for lack of a better word. Minors' names, if you include a minor name in a filing, you're supposed to use initials only. Dates of birth, the court suggests or requires that you use the year of birth only. Filers are to use no portion of the following: Social Security numbers, bank account numbers, credit card numbers, charge account numbers, and debit account numbers. The rule says that only the last 4 digits should be used of all these things listed here. Now it's interesting, I think we all experience, sometimes we see filers put only the first 3 or the last 4. I mean, it really varies, but this rule requires that the last 4 digits of this type of information be included in court filings. And the court says to filers to truncate email addresses, computer usernames, passwords, PIN numbers, or any other sensitive information as defined in a court order. It doesn't specifically tell you how to, it just says truncate it. Now, this rule has a number of exceptions that make sense. If you have an account number that identifies property that is the subject of the case, then obviously it has to be in there. So that you would not truncate or mask that account number if it's critical to the subject of the case. The record of an administrative or agency proceeding is not subject to this rule. Record of appellate or review proceedings should not be, sensitive information, those should not be minimized. And the date of birth of a minor when the exact date is necessary to maintain jurisdiction. The list of exceptions goes on. The name of minors in an order regarding parental responsibilities, for example, time sharing and support issues. The date of birth in a writ of attachment or in a notice to payor. Information used by the clerk of the court for maintenance/management purposes. Information relevant or material to issues before the court. I think that would be, for example, you might have in a divorce proceeding, argument over entitlement to investment accounts, the money in investment accounts. Obviously, you're going to have the specific account numbers in the documents to be able to identify what accounts someone's entitled to, what's in them, when they were established, and so forth. So I think this is a broad exception that would allow someone to put sensitive information in the documents. And exceptions, traffic and criminal cases, as we described for now. Next I have, these are proposed amendments to the minimization rule that are, they're not effective, these are proposed. Again, the court realizes that they did have to address this issue of minimization in traffic and criminal cases. So those committees that worked on this issue came up with these proposals. That in traffic and criminal cases, pro se filings would not have to be minimized. A court filing before charges are filed that are not filed, as any part of any documented criminal case. That's what that means, but arrest and search warrants, a charging document and supporting documents, and a statement of particulars. So those are, we'll see what happens with that. Again, there hasn't been a decision by the Supreme Court. These are additional proposed amendments that discovery information and evidence were filed with the court, and information necessary for the issuance of a subpoena to subpoena. So again, in a subpoena where you're asking for records of investment accounts, for example, it has to contain account numbers. It just has to. with these confusion about the clerk's role and the minimization rule. I know there is a lot of confusion. I have attorneys that call me and say, you know, are you guys going to protect driver's license numbers under the minimization rule? I said, no, clerks do not have a burden to do that. That's on you as a filer. And I think it's important to get the message to our staff members that, you know, it's very important that we don't have authority to protect this information that's considered sensitive. It's very different from the confidentiality rule. There's a lot of confusion because of the inconsistencies between Rule 2.420 and this minimization rule. And I mean that some information is considered sensitive under the minimization rule, but it's not confidential under the confidentiality rule. That's, I think there's a lot of confusion about that among the legal community especially. But I do want to point out too that in the minimization rule, in subsection D and E, they're very important rules that you can point out to people that question you about this. The court was very careful to say in subsection D that this rule does not restrict the party's right to move for a protective order, to move to file documents under seal, or to request a determination of confidentiality of court records. And under subsection E in their rule, it says this rule does not affect the application of constitutional provisions, statutes, or rules of courts regarding the confidentiality or access to public information. So that's very important to point out to show the difference between the two. In child support orders, actually I've encountered a judge that called me to say, now I'm going to put the full child's name and dates of birth in the final order. I want you all to truncate those on the original order. And, you know, I think I'm not the only one that's encountered that. So we can't do that. It does present a quandary to the court and to filers as to what they have to have in their final order and how it's ultimately going to be filed and protected in the court file. But that's not a clerk function. We cannot do that, and it's not our duty, and we don't have any authority to do that. Partial Social Security numbers. Now this is interesting. The minimization rule says that the entire Social Security number is to be redacted or not put in a file. That Social Security number is also confidential under Rule 2.40, so we are to redact it. But there are a lot of rules and statutes and forms that require the last 4 digits of the Social Security number. So if you get a document in that has the last 4 digits of the Social Security number, do you redact it or do you not? And I think every county has a different procedure on that. In Marion County, we do not redact it if it has the last 4 digits of the Social Security number. But I think other counties,
you know, we were talking last night, if I recollect, and I think we got Debbie Puckett's in the room, and correct me if I'm wrong, if we get a judicial record that has 4 digits only, can you hear me? Okay. Then we will redact that also with regard to parties or persons who do not have a right to get copies of redacted records. That's correct? Well, that's correct.
We'll unredact it with regard to, you know, the parties that requested at appropriate times or statutorily if I have already get.
so, you know, I think everyone, there's not a clear answer to that. There's not a clear answer in the rule or the minimization rule. And so you're just going to have to figure out what to do in your own personal county. And then the last one I have is court directing the clerk to truncate. I already talked about that. A good example of that is in child support orders. So now we're going to move on to talk about the confidentiality rule, 2.420. And this over to Marion.
Okay. Just a quick word about the minimization issue as it relates to the confidentiality. Merrily and I and Mr. Shore sat on the Rules of Judicial Administration Committee that dealt with both of these issues and rewrites to the rules. And it was interesting to hear. It's kind of like, makes you think of the old saying about watching laws and sausages get made. May have been a little worse than that, actually. But it was interesting to hear the lawyers who are writing these rules, their perspective on how this is supposed to work. And there is, of course, a debate, as Kate said, about what it means when you have a truncated Social Security number or a truncated bank account number or whatever, and whether that then falls under the requirements of the confidentiality rule. I think the consensus of the lawyers who are writing the rules is that it doesn't. Once it becomes truncated, then it doesn't require the redaction. But that's not what the rule says. There's no guidance in the rule. That's just what they're thinking behind the scenes as they're writing it. So, as she said, we'll just have to see how the court comes through on that, and what the court's view is of what they've actually written, as opposed to what they intended to write. So, okay. Okay. So what we're going to talk about, and Marion and I are going to divide this segment, is what is confidential, why is it confidential, and how we keep it confidential. That latter question, Mr. Shore will be largely answering with his examples from Manatee has accomplished that. Part of the confusion that's, I can't do two things at once. Luckily, I'm not trying to chew gum, too. Part of the confusion surrounding this process of making information confidential is that there are several entities that are participating in the debate or the dialogue about what should be confidential. And they have overlapping authority, and we as clerks have to listen to all of them. Disclosure of court records in general is regulated by both the Florida Legislature and the Florida Supreme Court. The electronic disclosure of court records is similar but separate, and that's regulated by the Supreme Court pursuant to an administrative order. Rules committees of the Florida Bar advise the court on changes to make and how to word the language of the confidentiality rules and how to integrate the different rules. There's an attempt to bring all of the generic issues that cross across all the different types of rules, civil rules, criminal rules, traffic rules, whatever, into the rules of judicial administration, so that lawyers and clerks only have to look one place to figure out what the real answer is to how to handle this. But that's a work in progress. That's slowly coming. The individual rules committees are not particularly anxious to relinquish their control over their rules. And there's also always, among lawyers, there's debate about what should go here and what should go there. So that is something that will continue to evolve as the Supreme Court gives more feedback and as the committees meet on these issues. And then the Florida Supreme Court has established the Florida Courts Technology Commission, which also advises the court on technology issues, including issues of confidentiality and redaction, both in the process and the policy of how that should be done. So the two big, statutes and rules that regulate confidentiality, 11907-142 Florida statutes, and that's the one that we've had to deal with most recently, took effect January 1st of this year, requires Social Security numbers, bank account numbers, and debit charge or credit card numbers to be redacted from court records. As you probably all remember, that started out, that's been on the books for a while, but the effective date kept getting pushed back. Finally, they said, this is it, this is really going to happen, you have to do it now. And so we're all, I think, grappling with just how to go about that. We're all at various stages of having that implemented, and we'll talk later about some of the problems that we've encountered doing that, some of the diverse ways that we've tackled that task. Then there's Rule 2.420 for Rules of Judicial Administration, which came out for us, it was a great benefit because instead of the huge amount of potentially confidential information that exists in Florida statutes, that there had always been doubt about, do we redact this because the statute says so, do we redact that because the rule says so, how do the statutes and rules fit together? This rule gave us a list. At the time it was a list of 19, it's now grown to a list of 20, things that clerks automatically redact when they come in a court record. So now we have some clarity, at least, about what we are expected to automatically redact without any involvement from the court or from the parties. So, in spite of the fact that it's a bit of a hurdle to get over in terms of helping the bar to understand how it works, dealing with the paperwork associated and so forth, I think that in the long run, we'll all find that it's a benefit to us because it does give us some guidelines and something to point to when a party or an attorney says, why didn't you make that confidential? Say, well, number 13 here says, this is, but that's not. So I think that really it's a good thing, and if we can ever all get on the same page with it, it'll be really beneficial. The rule has gone through, much as many of you remember in the legislative session, some of the budget bills and the laws that affected Chapter 28, the clerk's fees, and agency fees, and all of that, went through a glitch bill process, and then some of the glitch they called it, and I don't know where we're at now, but I'm sure that's still being remedied. Rule 2.420 is in the glitch process this year. Apparently, Mr. Shore and I spent some time on the committee that's trying to deal with some of the issues that have come up, some of the problems that have been encountered, smooth those over, address the things that were left out, and generally make it work better. My prediction, having sat on that committee, I don't know how the others feel, but I'm anticipating a son of a glitch and maybe a grandson of a glitch. If not many, many generations.
One of the things that we encounter in these committees is that, and the purpose is good to have all the different sectors come together. But the problem is that I think the legal community, by and large, and Marion and I were talking about this last night, the legal community, by and large, don't read half the time what they're supposed to. And second of all, they expect us to do things that we're not allowed to do, and they have no clue what we're going to do. And they're quick to say, is it just like? So we ran into a lot of this emoting, if you will, from the legal community. The judges tend to be more with the government lawyers and the clerk's lawyers than us. But, it comes to be a pretty area a couple of times, and I'm pretty biased, but I think pretty much I agree with Marion last night that our legal community really needs to be better trained, and they need to take the bull by the horns and go get themselves up to speed to do their jobs. And it would reduce our problems with the committee, really make hard on us, and really to get it.
It's interesting to see just the diversity of people who are in these people who are used to dealing with these communities and should have more familiarity than anybody else with the way these things work. And it was kind of surprising how little understanding they had of the way paper moves through the system, essentially, the way the records are actually processed, from their hands to the court's hands and back again. So it's a bit of a revelation for me. The good news in respect to that is that not a lot changed in the Rule of 20. And it's listed out in your materials what's in the Rule of 20, essentially quickly, Chapter 39, dependency, termination of criminal rights records, adoption records, Social Security bank account, charge debit and credit card numbers, HIV results, and patient identity within test results, sexually transmitted diseases, both test results and identity of the patient within the test results. And they specified in the rule when provided by the Department of Health or an authorized representative. That may or may not create a question when those records come through your offices. Birth and death certificates, including delayed birth certificates and fetal death certificates, identify identifying information in petitions by minors for waiver of parental notice of abortion, identifying information in clinical mental health records under the Baker Act. I know the issue of what's a clinical record has always been of some debate in our office and probably in various clerks' offices. That was discussed by the committee. I think in general they seem to agree with our position, which is that those are the records of the facilities that are dealing with these individuals. Records of substance abuse providers pertaining to the identity, diagnosis, and prognosis of and provision of services to recipients of substance abuse treatment providers. Identifying information in clinical records of detained criminal defendants found incompetent to proceed or acquitted by reason of insanity. And that, I think, is going to require some hair splitting, because I think that the fact that they have been found unable to proceed is probably not confidential. Then their treatment records and their prognosis and all the rest of it, once they're admitted to a facility rather than processing through the criminal justice system, I think is where the confidentiality kicks in. Because otherwise you would have a criminal court case with a confidential ending. And I don't think that's something that we're well contemplated. The state inventories and accountings, that's not anything new. And all of this stuff, as Mr. Short pointed out to me many times, this is all stuff that we all pretty much kept confidential anyway. Really didn't need a blueprint or hand-holding or guidelines for this stuff. This is stuff that we've all agreed on for years. Again, it's just nice to see it all put in one place and laid out in a list and given us the clarity that we had hoped for. Information identifying victim of sexual offenses, including child sexual abuse, gestational surrogacy records, and grand jury records. And continuing information required by courts and law enforcement agencies regarding family services for children. That would be your dependency arena, probably. Juvenile delinquency records, information disclosing the identity of persons subject to tuberculosis cases, pre-sentence investigation reports, and attached psychological and psychiatric evaluations. I think probably most of us were considering those sub-evals to be part of the PSI and keeping them confidential. But the committee felt that it needed to be clarified. They wanted to make sure that in whatever format they arrived at the clerk's office, they would be considered confidential along with the rest of the PSI. We actually, Marilyn and Mr. Shore actually argued that things that were attached could make it more difficult instead of easier, because sometimes we're very literal, and if it doesn't have a staple in it and it says attached, then that doesn't cover it for us. But what their definite intent was, if it's a report that's intended to go with the PSI, then we are intended to keep it confidential. Okay. Then moving on into the area of what is subject to restricted internet disclosure, you have a third document for the Supreme Court administrative order that was issued in 2007, revised general policy on electronic release of court records. And it specifies not just what is confidential, but what can be released on the internet. And again, there's some overlap. Some of the things are confidential, some of the things are sensitive, but not confidential. In general, the court, I think, was concerned about the issues of fraud and the issues of identity theft. They felt that it would be too easy for people sitting at home on their personal computers to extract information that could be used for improper purposes from internet records. And so they made an attempt to clamp down on that. You can still come down to the courthouse and get it. You just can't sit down at your PC and get it, except unless it falls under the list of exceptions provided in the order. Who can get access? Attorneys can get general remote access to non-confidential records in cases for which the entire court file is not confidential. That would be, I guess, adoption, juvenile delinquency, and dependency cases would be the three case types that were completely confidential. And then it goes through the list of what can be disclosed electronically. Again, that has not changed, so I won't read word for word through it unless you need clarification. some of the information then on the next page, on page 21 of the materials. What can be disclosed electronically if manually inspected? Those are things that you have to go through in the old-fashioned way, look through it, make sure there's nothing confidential in it, and redact it if necessary before you actually release it electronically. I don't know, but I imagine that a lot of you operate in your offices the same way we do in ours, which is now when we get a public records request, instead of making paper copies and sending them through the mail, we take the image, we make a copy of the image, we attach it to an email, and we send it by email. Those email images, or those electronic images that are sent in that fashion, may need to be redacted pursuant to this rule if it's transmitted electronically. Okay. So that brings us back to proposed changes to Rule 2.420. We have the current form, which you're probably all familiar with. Many of you, I know, feel that we've seen too much of it. You seem to have two extremes. Either the attorneys don't file it at all, or they file it not only when they need to, but when they don't need to, and in between. So I think a lot of it is, as we said, information that we would keep confidential anyway. We don't really need to be told to look for it. We know it's there. We know that we need to keep an eye out for it. I think the court's intent was really to be helpful to clerks. I don't think they were intending to make our lives more difficult, even though maybe the way it turned out in some respects. But I think they were really trying to say, clerk, we don't want you to have to go through 500 pages of documents and figure out where the confidential information is. The filer should know, and the filer should tell you, so you can go to it and redact it without spending all day. However, the rule does still give the clerk the obligation to look at the document and find it. And so even if it's not pinpointed as accurately as it should be, you do have an obligation to look for it, find it, and redact it. The proposed changes to Rule 2.420, I think Meryl's going to take over at this point, but some of them are big, some of them are small. The first one, I think, is probably just a matter of common sense. I'll let you talk about that. And then, as you see, we will get into some that are really going to require some thought on the part of all of us in drafting best practice or in coming together and trying to create uniformity in how we deal with this, because they've added some significant changes that are going to affect our offices to a large extent.
Yeah, the issue of the filer is, and I know it's going to be, and
I'm like Marion. Good thing I'm not chewing gum. Okay. The issue with the filer is, there ultimately is going to result in whether or not the person tendering the document is going to fall within the number of people that are listed as the filers, and whether it's expansive or restricted and all of that. We always get into that. I think it's a pretty good list, and it may not give us much problem to begin with, but as we develop, I'll be interested to see how that gets reinterpreted. We have to allow, of course, records to judges, persons authorized by law and court order, and what happens there, I think, as we're all transiting into the electronic age with our judges and our courts and the various agencies that are entitled to records, we are going to run into the issue of subcontractors to the agencies and what their rights and entitlements are under the new as well as the current time frame. Here's the real one that's going to really give us heartburn. There is a change in Rule 2.420 that now says that oral motions during the course of an event may be made in the court to determine confidentiality, and there will be paper. Our poor court clerk is going to be sitting there having to do something to identify this particular item, paper, evidence, motion, petition, whatever it is, as confidential, with no motion, no tracking that's going to go in our records, and 5 days to the filer or the person, the movant, to then submit the paperwork for that. Well, you know, we thought of a bunch of scenarios last night when we were talking about this, that we felt that probably every clerk's office is going to be very worried about this, particularly for their court clerks, particularly for their own duties and, you know, that kind of thing. And so how are we going to do the instant thing? For example, we started talking, of course, about Trayvon Martin and George Zimmerman and that trial, and what's going to happen if somebody makes a motion in the course of this trial. You know, this is the biggest example, and I figured everybody's going to get it here. Standing out in the court or in the courtroom itself, there'll be a bunch of reporters, and they're going to want to see every last letter of the alphabet that comes out. So, somebody makes an oral motion. What happens? You know, how are we going to process all that? And we thought about it a lot, and we thought, oh, this is going to be a nightmare. Some of us talked about maybe we could, you know, have a stamp like we do for our redaction stamps and that kind of thing, and the court clerk could stamp it, or we'd have something in whatever our forms are that come up that would indicate, okay, this particular thing is, you know, in that 5-day scenario. I just don't know, and I think many of you here probably have a stronger grasp on that particular issue and how you might manage it when it lands on you. We do have new time frames for the granting and the denial. A lot of our discussion, both in the committee and among us here sitting before you, had to do with if you had that motion that you wanted to be sealed, what happens at the end of whatever the delay time is, whether it's the 5 days, the 10 days, the 30 days, and the new time frames. What happens? Do you bring it back out to the public if you don't have a motion, A, or B, if you have a motion and you don't have a notice for hearing? How long do you keep it sealed from the public? And is that a contravention of Article 1, Section 24? Now, you know, we like to sit around and cheese our brains, but it's going to be a prominent thing that's going to come up because the question's already hit my desk in the past 2 months. And I said unseal it at the end of 30 days if you don't have the proper motions, notices, and that kind of thing in conformity with the current 2.420 and what you're going to see in the new one that comes out. The list of 20 and the clarification of the pre-sentence investigation model, and that is see attached, you know, how we're going to all handle that. I think the lawyers have to act like lawyers, and they have to stay within the body of the pre-sentence. Well, the pre-sentence comes from PTR, but they have to, the people submitting it and the lawyers, you know, dealing with it have to say, this is an exhibit and note it in the body, and they're going to have to fix their forms to go along with that. How that's going to work, I don't know. We had a massive amount of discussion about the form, the notice form. Currently, it has the 20 list on it, and what we determined is that the notice form would no longer include the 20 because predominantly it's going to be a public record. And if you have to tell the clerk that the thing that you want to hold confidential is the records for HIV, well, wait a minute, that is a problem. So what we determined to do, and what we've recommended to the Supreme Court, is that we take away the 20. And sorry, I know that that does create, and again, I'm talking about the problem children here, that does create a problem for all of us to determine what it is and where it is in the record if the attorneys don't follow the rule exactly as it's set out. Because if you follow the rule, you don't necessarily have to, on the notice form, have to have those things. You just have to have a page number, or you from your docket, or from your submittal. But we just really kind of got into a kind of a fit over this. So what we did with the new rule, and it was really a split thing between us, and Mr. Shores is going to address that because he doesn't think we need the notices at all. There is, because our new electronic systems should be able to manage things, but, it depends on where we all are in our various steps. But what we decided to do was send both the short form and the long form to the Supreme Court, asking them to please give us guidance on that. But right now, the short form specifically says, as in conformity with the rule, that you have to set out the precise location, page number, and all of the different locations that you want the clerk to either A, seal up or cover up, keep from going on the public record, and B, if you want specific redaction of materials, which is kind of different than confidential, then you have to say that on the form, but you have to do it in such a way that we can find it without disclosing confidential matters. We did that, okay. I have to change views here. Okay. Procedures for filing the short forms and documents previously filed with the clerk. That's going to wind up with both pretty much a notice, and it may require a motion, because if it doesn't fit any of the list that we have to take care of, then they're going to have to probably get a court order. There's a lot of confusion in the legal community on these issues because they'll submit motions, they'll submit notices. Particularly and my experience right now has been with the small claims court. And the small claims court, they, in order to make out their, stuff, they have to put in the bank records. Well, when they put in the bank records, they're making motions to seal. They're not telling us what the issues are, or they're not telling us where it is in their particular package that they've submitted to the court for review. And in effect, they may really not have a basis to require the clerk to close that whole record. It's rather a redaction issue as opposed to a closing. And so what happens is they don't tell us enough, and then we have to give them that 5-day notice, and then they get kind of huffy with our people, and things kind of go downhill from there. And you recommend to an attorney, could you just please read the rule and do what it says, and we'll be happy to work with you. And I don't know, I had one attorney call me up and say they were going to sue us because even if the rule was what they were supposed to be doing, they weren't going to do it because they didn't like it and it was unconstitutional or something. I said, well, we have to do what the rule says, and we need to understand that. I know you've all had this experience, right? Procedures for notifying affected non-parties. This one is going to give us all fits, I think. Although it's probably not going to fall on our shoulders as much as it will on others. Because when you have a notice requirement in some, give me an example because my brain just, but in some cases before the court, you'll have a notice requirement to the victims of crimes, for example. And because something is going on either in the criminal case or in some civil matter that affects the criminal case, these people are entitled to get notice. But the problem is when you give out the notice, you can't put name and address on it and how we're going to handle it. And so we now have a requirement, and get this, I love it, that the judges will send the notices to these people. Okay, let's see how that's going to go. Okay. I'm sorry, folks. I guess I'm just getting jaded here. So, we have added a procedure in the new 2.420, and incidentally, it's before the Supreme Court right now, and they have sent us all a notice that there will be no oral argument, so I'm anticipating that we're going to get the promulgation and publication of this, because it's been through the whole process of, we talk about it, we send our comments, blah, blah, blah. I'm expecting it shortly. I don't think a lot of time is going to, maybe by June. What did you say? Yeah, okay. We added a procedure for noticing crime victims parties, as I've just talked about, and we're all going to have to figure out whether or not we have to have forms for that, or whether the judiciary is going to take it over. If you could put us up on to me. Yeah, the short form. This is the proposed new short form. I don't know what the Supreme Court's going to do, but you'll see that it still does require the title and type of the document, the date of the filing, the date of the document, if there's a docket number, because it's already in the record, as in those motions for, fixing a glitch. If any of them are there, but they need to tell us it's on docket number 27, for example, in the record. They need to check or tell us, there is a box to check that the entire document is confidential, and that the precise location of the confidential document exists. And beyond that, I think that's the best we can do to balance the act out. Let's go to the next one. Okay, so like I repeated, we went to a long form that includes the different entitlements under 2.420 D1B, with a big B, and that list, which is what Marion was just talking about. It's here, and we're telling the Supreme Court, you make the call, because we really, as a group, pretty much felt like if you're following the notice and you're not going to file a motion, make even the notice confidential, or will you have to, that is a disclosure on the public records of certain confidential. And we'll see how that's going to come out. And I know you all kind of like the long form, and I've had this conversation with staff members in Brevard, and it really is an extra chore if they aren't given the precise location and page and number and what they're looking for and that kind of thing. And we're still working to figure out what our software is going to do and all that sort of thing. So we'll see what the Supreme Court is going to do. I don't know. I can't even call that, because I know it was a battle. It was a big, big battle. Oh, sorry, about the redacted copies to the clerk. Push back to that. Thank you. Yeah, 26. Yeah, we have a requirement that judges, magistrates, and hearing officers who create documents, including confidential information, to identify a document that contains confidential information and B, provide a redacted copy to the clerks. Again, okay, let's see how that's going to work. Them doing notice, they're providing redacted copies to us, we'll see. Because that means the Judicial Administration is going to have to figure out how to set that up so that we have that document information flow. How we will handle that, who's going to do it, how's going to get it together. And I think we'll worry about that probably come July, I'm going to guess. Some of the concerns here I've already started to talk about. One of them is that the filers don't identify the matters properly in many instances, even now. Even with the long form. And as I described, I've gotten into a couple of instances where attorneys are calling staff members and reading them out about constitutionality, and they better do this, and they're breaking the law, and they're going to get sued. And, I reviewed the document paperwork, and they hadn't complied with the current 2.420 because they hadn't done the specific location and that sort of thing. And what are you going to do? You tell them no, and they get all upset, so no. D2A may provide, when the filers start providing us with these documents, it may provide insufficient information to, and this is me with a minimal understanding of how electronically all of this is going to work, and I'm going to defer to Mr. Shores when he gets to that part, but, you know, in my understanding, when it comes through the e-portal ultimately, and it's, you know, the different things are going to go into queues, and Gypsy Bailey was talking about this yesterday, that, you know, they have it going, and Marynelle's group, they have it going, so maybe my worries about with the new rule, how it's going to work, and how our queues are going to work, and how we're going to, you know, manage this from the portal are ill-founded, and simply because I don't have the technical background to actually exploit it, but I would say that we all have to at least focus a little bit on it to make sure that it works properly, because it is our duty to do our very best effort to make sure that whatever the rules of the statutes tell us to redact or close, we do. We're going to make mistakes. We can, in my opinion, but we can't do it unless we've got best practices, you know, best duties, everything. Again, I've talked a little bit about the no action. If no action occurs after a move for confidentiality, I'm in the camp that says that we got to put it back out on the public, because it's up to the filer, the mover, the attorney to look at it and say, okay, I have to do some things here because the rule is going to require me to, and if I don't, well, then it's on me that it's back on the public, because we have that equal and opposite, you know, pressure that we have to have public records, and when we get public records requests, we've got to supply it within a certain amount of time. And if we don't, we've got the grounds for complaints against our offices, and in particular our clerks that we work for. Again, that oral motion to, and I'm hoping that when we get to the Q&A section, you'll all want to talk about this oral motion business in the court with the 5 days and the notice to parties. We come under 119.0714 in the Florida statute. Okay, because we have to really worry about the public records, the confidential records, the exemptions, and the queues. And in each one of them, our duties are going to separate out into confidential that we're required to recognize, confidential that we're asked to recognize by a filer, and then it's not a total record confidentiality, but the filer doesn't understand, and so they're asking us to, you know, seal up a record or close a record from the public record when all it really would get would be redaction, and we're required to do that anyway. So there's a lot of confusion there, I think. And I'm hoping that some of that will get worked out with training sessions. I would mark that as also one of the things to talk about. I decided to talk to you all about, even though this is a little bit outside of the realm, but 2.516 is the proposed rule for email service. And on 36, it starts to come up. I'm not going to spend a lot of time on this. I'm just going to tell you that the committee has proposed to the Supreme Court a method, because the e-filing portal right now does not provide e-portal service of documents for any of the levels of personnel. But what we can do under 516 is do it by email when we have to serve things, unless it's required under the statute specifically, or whatever relates to the generic thing we're doing, that it be served by subpoena or hand or mail or something like that. But for the most part, we should be able to rely upon this service of pleadings by email. Again, there will be instances where this electronic service is going to require a redaction, so we got to think about that when we do it. In my own experience as an experiment, my supervisor in probate and guardianship, which is under my office, came to me one day and said, you know, we're spending a heck of a lot of money on postage to send out the reports to the court after we've done an audit. And then she told me it was some big number, like $30,000 or $40,000 a quarter or something. I was like, oh, really? So she went back, and then we put our heads together, and she recommended if we got hold of all of the attorneys and asked them how they felt about e-filing, receiving their service records by email, would they agree to it? So kind of ahead of the curve and ahead of what this rule recommends, we did that. And I think we're probably walking on the razor's edge, but I'll do that now and then. But it has certainly saved us some money, and we are getting wonderful feedback from both the attorneys and the guardians that they love it. They can't wait till it's a real formal process. So in the interim, until e-filing for our group gets certified, and that's how we can do it, service through the e-portal, we're probably going to do as much of the email sending as the law will allow us to do and not do a paper thing with. And I think that's all I have to say. Okay. And I really hope that you all will want to talk about this. And I think you can find a copy of this presentation on the FACC, so you'll be able to get out that 2.516 so that you can read it yourselves. I'm not really sure when you can take it. But anyway, we'll get that information.
Now, this is Vanessa.
I'm going to talk to you a little bit about the redaction process as we've experienced it in Broward County. We talked about the rules that affect these court records. Implementing those rules along with the 119 provisions has proven to be more difficult than we would have had expected. At first, it seemed like it wouldn't be too much of a task because we were already, for the most part, pretty used to keeping certain information confidential in court files. But I think the biggest problem that we've encountered is the new Social Security bank account, debit, charge account numbers that our staff just was not used to looking for in the court file before. I think it's easy to identify those numbers and redact those, but when you throw the other rules into the mix, that creates the confusion. We have staff who, they don't know what to do. If we get a new judgment form that includes the last four of the Social Security number, do we redact it? Do we not redact it? That judgment needs to go to recording. Do we redact it before we send it to recording? Do we wait and do anything after it comes back? There's a number of exceptions where this information can be provided. For example, collection services. We've had an issue recently where our collection service said, well, you're not including Social Security numbers anymore, so we can't collect, or we're having difficulties collecting. And we had to explain that we're not being provided Social Security numbers anymore. And I don't know what the outcome of that would be, and I don't really know what other methods they have, but there's always something else. You come up with one solution and you find out it affects the next. But some of the things that I'm telling my staff is to remember that we have that duty to not disclose the information, and regardless of whether it makes one of the parties or an attorney unhappy, we need to redact the information. So for the example of the new judgment forms that I gave you, I advise send the information to reporting. We have a separate reporting agency in Broward County that's done by the county and not the clerk of courts. So we know that they have a duty to do whatever redaction is necessary on their part. When the information comes back, it's going to be part of the court file. And I said, now that it's part of the court file, it's part of our record. And so we have a difference of opinion in our county where I said, for now, let's go ahead and redact it because we are tasked with redacting the Social Security number. Even though it's necessary for the judgment, I feel that if somebody is needing to enforce that judgment, they can get an unredacted copy to serve the purposes. I see a hand up.
Yes. What about those
go through each page and redact those numbers, Social Security, bank account, blah, 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 numbers. I have thought in terms of, sending them through our, scanning them. But it would still take almost as much time to do that after you take out all the paper clips, so on and so forth. What would be your suggestion? Take a number or come back in 3 weeks and you'll have this court file available for you to review.
Okay. I don't know if everybody heard that question, but it had to do with the records that are currently in the court files that have not been destroyed and are still within the clerk's files. What to do with the confidential information, whether to go back and redact everything, scan everything, redact it. When this rule first came out, we looked at the possibility if there was any way that this could possibly be a day-forward item. And when the rule refers back to Chapter 119, and Chapter 119 is very specific that the bank account numbers and Social Security numbers and any other confidential information that is in that file are to be confidential, whether they are held before, on, or after the effective date of the statutory provision. So that kind of dashed our hopes that maybe we could just do this on a day forward. What we have done in Broward, because we are not electronic yet, we are in the process of becoming an electronic county, but we actually have a redaction room with staff whose job is redaction. And a person who needs a file can go online to the website, and we have 2 different forms, a request form. One is a regular request form. If you just need a copy of something out of your court file and you don't need it immediately, you submit this form, you explain what it is you need, whether you need the whole file or you need to just view it, or you need a specific copy of something. You submit it, you can fill out the form online, and it's faxed or emailed to the proper division, and that file is pulled and gone to the redaction center, and once it's been redacted and marked as redacted, then the person is notified that the file is ready for them to view. We have a second form that is a priority request form, and I don't know how well that's going because I think that most people feel that their issue is a priority. But the form does state, even though you're not supposed to ask why a person wants to view a record, it does state what is the purpose of this. Do you have a hearing coming up? Help us, help you, kind of thing. We try to help people if they need something prior to a hearing so that answers can be filed or other motions. The problem that we've had with these request forms is that people are downloading them and sending them in to the divisions asking for the status of their case or how much money they owe for a traffic ticket, and they're using it more of a means of communication than really just asking for the file. At this point, because this is a very new process for us, it's what we have, and we'll see. I'm sure that we'll have to work out a lot of these little glitches here and there, but the result of this is the file is pulled, it goes to the redaction center. Right now we have about a 5-day turnaround for getting those files back to the party who requested it.
Okay. One more question. In Volusia County, we've had a lot of class action suits. So apparently we have, in the old days, file cabinets full of records. How do you, and of course, they're old, and we haven't actually gotten to them to scan them. We have tried taking the documents and digitizing them with special software. That's not working really well. We do have good redaction software, so I'm not concerned about that. What I am concerned about is how labor-intensive it is to take all of the, paper clips and for the you know, we could get into a number of volumes of court files.
I think that's something that all the counties will struggle with. It's something that we have had to look at in Broward. We're a very high-volume county as it is, and we have a number of records that we're still retaining. Because we're not electronic yet, I envision in the future as we can scan records and have the auto redaction software take place, it'll be an easier process. But for the files that are sitting on shelves, we are not, at this point, reviewing every file. We're doing this on an as-requested basis because the information is confidential to the public. So if the public wants to view that file, we have the duty to redact. At some point, all the records, I'm sure, will have to be redacted, but there might be a record that never gets requested and then it meets the retention schedule and it's destroyed. So you have to focus on where do you put your efforts. So that is what we're doing in Broward in terms of records as they're requested. Now, the records that are needed for court obviously go to court unredacted. The judiciary, they are entitled to see everything, and I think that we have an obligation to provide whatever information is needed for the hearings to be held. Our biggest struggle at this point is the attorneys who want to view unredacted files. We have not made the determination that attorneys are not public, or that we say they are members of the public, regardless of standing with the Florida Bar. Because there's not a specific exception that allows attorneys to view the file at this point, we are erring on the side of caution, given the intent of the rule to maintain confidentiality and prevent identity theft. Our attorneys in Broward in particular are not shy, and they've been very vocal about not being happy about not getting these files quicker. At this point, I think they just need to put their requests in a little earlier, and eventually I'm sure it will all sort out. I have not heard many complaints about members of the public who wish to view the file. I think they're probably used to having to wait, or they understand. I think it's the attorneys who have been affected the most. I would like to see some sort of a revision to this rule that maybe does specify that attorneys of record, at least, are able to view the file.
Well, there's quite a few eminent domain cases there. There are quite a few eminent domain cases where probate attorneys have to make sure that everything was, their T's crossed, I's dotted, so on and so forth, in order to prevent a quiet title type case, and the person that they're representing is absolutely confident that their property was not taken with the eminent domain. This is only one example. There are numerous examples, and they are old cases. We are scanning. We've been scanning since 2000. Those are very easy. Our attorneys have gotten used to looking at the court files on record. Our public has gotten used to looking at those court files on record, online. Boy, I am not thinking it's too early. Everyone that we do business with is, for the most part, willing to look at their records online. And we have public terminals available in all of our departments as well as other places. So, my question again goes back to those older files that we haven't gotten to, and not quite sure that after three filing cabinets full of documents, whether or not it's so labor intensive for an individual to go through each and every document to make sure that the confidentiality of those documents are protected. That's all I have to say.
Well, and I think that what you're saying is something that we're relating to in Broward as well. We're just not redacting a file that's sitting on a shelf that has not been requested. Because the clerk does have a duty to redact the file before a member of the public views it. Whether we decide to redact a file that's not requested, I think is still within our discretion. It's kind of a judgment call. If you have the staff and the availability to have everything done just in case, I think that's ideal.
We wouldn't redact it unless it was requested.
Right. And then in that case, I think it would need to be redacted, even though, and that's where the notice to the public and any requesters, it would have to be known that it takes a little bit of time and they will get their file because of the new rule. There's a redaction requirement. We actually have signs up too in the different divisions, as well as a posting online notifying people that unfortunately now things will take a little bit longer. Did you want to address that issue?
This is probably going to stir things up more than I intend, but we may as a group want to look at the viability of applying the portion of 119 that allows an extra charge for excessive amounts of time or large amounts of time that are required responding to public records requests. I don't know if it would apply to these redaction situations, but under the circumstances, it might be worth taking a look to see, what the consensus is about that, because it is very labor intensive when you have to go back. It's one thing when you can run it through a program. It's another thing when you have to have people sitting and looking through a 6-volume file.
I doubt that would apply, but I could be wrong. I'm really kind of wondering if there are those out there that might be handling that in a way that would help, if you deliver that information. Is there anybody out there that's doing it differently?
On that. If the person requesting file is a party, do you do the redaction?
I'm glad you asked that question because that was something that I was going to address. At first, it was seen that a party would obviously be entitled to the information. It's their information. But when you delve deeper into particularly civil cases, or maybe you have a criminal case where you have more than one defendant in a matter, there's always more than one party involved. And so I see that there's no way to get around it when you have more than one party. If it were solely just that party involved in this matter and no other person's information could possibly be in it. But you don't know that until you go through. There's a plaintiff and a defendant, and everything needs to be redacted because I don't think that the rule allows for the other side to potentially see some of that confidential information.
I'm not sure because Dade County, if they're a part of in the case, we can go ahead and let them see the file.
Right. And I think that every county will probably make a different determination on who can view. And these are good examples of why the rule needs some further tweaking so that we're all on the same page. We really need a statewide best practice or a rule revision so that we're not all doing it differently. I hear all the time about how this county does it differently and that county does it differently. I just have to explain to the people who are usually the attorneys who are calling and complaining about it that, clerks still have autonomy in each county and we have to do what we think is best. And in our county, we're trying to just err on the side of caution if there's any doubt. But practically speaking, that doesn't always work. You'll always have somebody who will argue it or say that they are entitled to it. And this is a very new process that we have just implemented, and I'm not hearing all the issues yet. But I know that there are a lot more issues that will probably come down, or it's possible that the attorneys will get used to this process and they'll is always hovering over us. We just have to be very careful, especially when it comes to information that could ultimately lead to some kind of identity theft or some other issues. So,
I'm sorry, I can't agree with you. The SCTC has already ruled on Manatee's redaction process and ruled that it's okay. We release documents to a party. I don't think you can keep it from them, and so far there's been no problem with it. We also release to attorneys of record, which is allowed in the rules. So, that's I don't agree with what you're doing, because in the paper world, they walk in, you're required to do it.
Chip, what rule does that allow you to release to attorney records? I'm not familiar with it.
It's in the Supreme Court rule. I'll get you copies of it.
Thank you.
Now, I spoke about our manual redaction process in the county, which is the majority of our records, but we do have some e-filing in our probate division. And fortunately, that portion is going very well with the redaction. The redaction software is programmed, and we have to be very careful, I guess, that the software keeps up with the rule changes and how things change between whether a 4-digit is allowed or no digits. But fortunately, on that side of it, probate is one of our smaller divisions, unfortunately. But once we get up and running with e-filing, I think this redaction process will go much, much smoother. Eventually, with parties following the minimization rule, that should take a huge burden off the clerks as time goes on. But right now, I think we're all dealing with the crunch of all those files and the backlogs. And unfortunately, that it's just something that we'll do, we'll work through, and we'll wait until the rule changes again.
Open it up, we started, and that was our intent, to open it up for comments and questions and answers. So, okay.
I'm well aware of the fact that the attorney of record and the parties on the ratio that they are in fact the same same person. The attorney of record has access to all judicial files. I don't know that there's an issue there. Chips, could you answer that?
Yeah, it even goes further. If an attorney of record or somebody in the case allows someone else to look at it, for instance, an attorney of record handles it, but the people want to go to another attorney, they can give us a release saying that attorney can look at it, and that's allowed too.
That would be correct. Next question.
In the minimization rule that requires that minors may be initials only, does that include in the style of the case? We often have civil cases where minors are a party, either the plaintiff or the defendant.
Well, that's a good question. I mean, again, I don't know that it would be smart to put the initials only in the style of the case, but then it defeats the purpose of the rule if you put the full name in and you minimize it everywhere else.
But then you get a judgment in favor of TW.
Mm-hmm. Well, this seems like the easy answer for us, but that rule, we have to be aware of it, but that's an issue for the attorney to decide on how to file it. It's not our rule. That's a great question for those people filing.
One of the things that we have discovered in our discussions coming to this day is that oh, what does that mean? Does that mean that if a party can get the original and then later on comes in for a certified copy, from a record, can we give them the certified copy unredacted, or do we have to redact if there's that kind of information? On and on and on. There's more questions than answers. And I think in practice, we're going to discover, and I hope it's not going to kick us in the shins too much, but, I hope it's going to work. And as Vanessa said, we're worrying before we get there, and it really may work out okay. Maybe the filers will do their jobs and do the minimization, and we won't have so many issues of conflict between statutory requirements in 119 and 39 and 63, on and on, and the rules themselves, which I know will give us all fits on a daily basis. On that really old records that were just a project, what do some of the others of you do with the really old records request when it comes in? You redact them individually, but you're not going back and trying to do a big redaction scene. Okay, you're going to do it. Okay, what's your key point, before and after that?
What we're doing is after January 1st, we're reviewing all the things that are coming in. But anything back, we're not. If there was a request, we go back backwards. We'll be party requested, and if they're part of the case, we will
Okay, so for purposes of your online, the requirement that we allow the public to do online viewing of public records, if there is, that looks like it's more and more of a requirement.
We did a public before we allow them to do the kiosk. If there is a party in the record, then we go ahead and allow them to get the kiosk. It's not that in every place where someone has to view that first, and we're able to do it right then and there, but not that we have to do that.
Okay, so they get kind of appointed for that.
Redaction, scan it back in, redaction copy, and redact.
Well, we have records, in some cases, for example, in minor's guardianship, where you have a disabled minor, and, the minor is going to live to be, hopefully, right of old age, and that guardianship is going to go on for that amount of time. So, who's entitled to view those records? What do we have to do when the request comes in? And what if a party who's no longer a party, but has a notice of interest comes in, wants to get a copy of the letters that were issued in 1942 or whatever. And, what do? Do we redact it? Do we give it to them? Do we certify? How do we do it? So I think these are all questions that you're all struggling with. Anybody else got any more ideas on that issue?
I'd just like to point out one thing on the issue of whether just any party can see anything that's confidential in the case. I agree that's the general rule that they can, but we still have to be very careful because if it's a trade secret case, that's the perfect example of something that someone would have to look at that file and make sure that you're not handing it over to the other side that's not supposed to file these top secret, trade secret information. So I think giving information to the parties and attorneys of record is the general rule, but we always have to be very careful. Also, in criminal cases, there are a lot of ex parte motions with the defense basically asking for payment by the JAC for certain doctors. They don't want the state to see it. So there are those unusual circumstances that not all parties can see everything.
Once again, the rule says that the filer has to tell you if it's a trade secret or something like that. If they don't, and they don't go to court to get it sealed, then there is no liability to the clerk.
No, I agree with that. But if they have, and we've redacted it, but you've got an attorney of record walking in and just wanting to see the hard copy of the file that hasn't.
I thought it became like sealed, and if he wanted to see it, he'd have to go to court. That's the way we're treating it.
That's how we want it. It was already sealed, so we will treat it as that. But the review for the redaction was very right. That was right.
Yeah, requesting parties can't see Social Security on those things. The magic 20 has to be out, period. The other question I had was on the forms. I have a real problem with the forms. And quite frankly, no matter what the attorney fills out on the forms, it does not release the clerk from their liability. So to me, it's just dumb to have them fill out a form that we're going to have to go through and review anyway. And all it does is cause the attorneys problems and make them not want to e-file because they have to do all this. And the courts still hold us liable. Now, if the courts change and make Filer liable for all of that and take the liability off the clerk, then I can see the reason for the forms. But other than that, we're still liable. I don't see the reason. And that's all I'm going to say.
I think we all, those of us sitting up here, have gone and talked with our different departments to try to see what the problems, would be if we didn't have the notice form, or whether we needed more requirements in the notice form, et cetera, et cetera. And I would probably, if I were to go around here and poll the different counties that are here today, I'll get a slightly different answer depending on what stage you're in for the redaction process of your records, what stage you're in for having to go live on the e-filing, what stage you're in terms of your public relations and how your public records request, and what kinds of things you can anticipate, and all of that. I think what we're all trying to do, again, is the best practices. Because, we do have a duty and we do have to go forward. I'd love to do away with the notice forms, but right now, I think because we're all in different stages, we might have to kind of live along with them for a while and hope they give the various counties the kind of information they need now. But once everything is done in the e-filing, I think that matter should be revisited strongly. Because the file, yeah, it's stated, and we have, right, but once we get completely electronic, which, it might happen a little more quickly than some of us think. It's scary, I have to tell you, as much as I really like computers and all of that, I do find it a little making me uncomfortable. But we'll see. I really think that everybody has good